Hello, and welcome to the summer webinar series on competency restoration, brought to you by the Texas Judicial Commission on Mental Health. My name is Molly Davis. I'm a staff attorney for the JCMH. The Judicial Commission on Mental Health was started in 2018 with the mission to engage and empower court systems through collaboration, education, and leadership, thereby improving the lives of individuals with mental health needs, substance use disorders, and intellectual and developmental disabilities. Competency restoration is one piece of our work. Today, we are excited to have 4 experts here with us to tell you what you need to know about competency restoration. There is a lot to cover and just 1 hour. We might have some time for question and answer, so please drop your questions into the chat and we can get to those at the end. And please welcome from the Dallas County Public Defender's Office, Assistant Public Defenders Vickie Rice and Jason Foster. And from the Dallas County District Attorney's Office, Assistant District Attorneys Kendall McKimmey and Pierson. Dallas folks, please take it away.
Thank you, Molly, and thank you to everyone for joining us today and having us here. It's always an honor to be asked to speak or present. What we're going to try to do today is walk through Competency 101, giving you some practical pointers. We do have a slideshow that we will share, but we'll be bouncing back and forth, having different things that we do and kind of going through and presenting some things for you. We will kind of pitch things back and forth to each other. We've all worked together for a long time. I start any introduction about myself with how I met Vickie. Vickie walked into me 13 years ago when I first started with Dallas County, and I'm cleaning this up a little bit. She goes, "Are you a jerk or are you not?" And we've been fast friends ever since then. We've covered for each other. We've watched out for each other. When I took over the competency job, Vickie was one of the people that sat down and helped me figure out what I was doing because I had no idea. There were lots of folks. There were some judges that helped me. There was a staff attorney, but Vickie was right there in the trenches with me and has been there ever since. You'll see kind of some recurring patterns as we go out through this today. Collaboration is key. Working together is key. Coming up with different solutions is key. Just a quick example. We had our end, me and Kendall, set up to be in a totally different location at 11:46 before this started today, and that didn't work. So everyone on this team got on here, and now we're from a different location right on time and ready to start. Kendall will tell you more about herself, but Kendall does the competency job for Dallas County, the felonies, and she's got this stuff down pat, the intricacies of it. She prepared this slideshow and has all the intricacies. At the end, if you don't have time for questions, we can give you all of our contact information. Feel free to reach out to us, and we'll always help in any way that we can. Vickie?
Yes, it's much like Lee said. We like to view ourselves as like basically 6 degrees of Kevin Bacon. Kendall's husband used to work in the public defender's office, which is how I met Kendall a long time ago. And Kendall introduced me to Jason, and we hired Jason in. Jason and Kendall worked with Lee when they were out in defense practice. So when we say collaboration is key, we are like one big family because you are going to be tackling some very, very, very challenging subjects. You're going to be asked to make some very difficult decisions, and having faith in the individual that's bringing you the information is going to be paramount. So working together with respect and integrity, I cannot tell you how important it is. And it's as Lee says, the collaborative piece. If you don't have the collaborative piece and you don't have people who are coming to the table willing to think outside the box, as we frequently say in the public defender's office, there is no box. You have to come with a blank slate, ready to do the hard work and ask the hard questions and make some very hard decisions. So with that, as Lee indicated, I've been with the office now, I don't even want to begin to think about it, almost 24 years. And being, I would say, the person who has the most senior experience, there is not much I have not seen in competency. But I'd like to kick it over to our newcomer, our rookie, as we call him, our little Lightning McQueen, Jason Foster, because for him, he is that breath of fresh air in this monkey cage. Since Kendall, Lee, and I have been doing it so long, we decided that, you know what, we're a little old and crusty. We need some new kids. We need some new ideas. So, let me kick it over to Jason Foster to introduce himself.
Thank you, Vickie. As Vickie said, I'm with the Public Defender's Office as well. I've been with the PD's office now, this will be 6 years. As she indicated, I'm the newest, so I'll probably be learning a lot along with you guys. But that's okay. Hopefully I will be able to add some of that perspective, some of the things that I've encountered early on, and yeah, kind of go from there. Thank you.
And I'm Kendall McKimmey, and I have been doing this job for almost or over a decade, but the competency part for about a decade. And it has changed a lot in the time that I started till now. Mental health is more of a hot button issue. We have more cases. We're identifying people at a faster rate. The county itself is, in compliance with 1622, which we'll go through later in this as well. But we are identifying mentally ill defenders in the jail, which ultimately gives a more pool for us in the competency realm. So we're going to go through some stuff today, and we're going to talk about the law. We're going to kind of talk about how it is in practicality and how we do it in Dallas County. By no means does that mean that's exactly the way it's going to work for you in your county. So take what you can from what we give you, and we're happy to try and answer questions either at the end or contact us later on the side if you've got a particular issue in your county you might need help with that we don't address. So with that, we can start off with the law, which is found in 46B of the Code of Criminal Procedure, as well as Chapter 574 of the Health and Safety Code. Kind of jump around back and forth between the two because that is 46B of the Code of Criminal Procedure is what points you towards the Health and Safety Code throughout. And so you kind of bounce back and forth. So we're going to go through the slides. You should be able to see those on your screen. But we will also kind of jump around because we're going to round robin this. So we should be able to cover everything.
And just before we get started, Molly, can you see these on the screen? Did I get this done correctly?
Yes, they're visible. Thank you.
Awesome. Yes, ma'am. All right, competency. What is competency? There's the law that's on the screen. And competency is basically looking at, does a person understand what they're charged with? Do they know who the judge is? Do they know who the prosecutor is? Can they assist in their defense? Competency doesn't mean that a person doesn't have any mental illness and it has no sort of challenges or anything like that. It's the bar of, can they help with their case? Do they understand? As Kendall said, it's in these two sections of the code here. Many times you're going to have to consult both. Vickie, do you want to add anything there?
Yes, as much as you said, Lee, 46B is going to be your Bible. It's going to guide you. Competency can be raised any number of ways to make a determination. It can be raised by that of a jailer, a judge, a prosecutor. Even family members could come and say, hey, have you met with such and such? He's been off of his medication. But at the end of the day, you're going to frequently see it's often the criminal defense attorney that raises it. And once it's raised, you have that duty that you have to do to investigate it. If you don't know 46B, you need to take an opportunity to process it. 46B laid on top of the Health and Safety Code can be very convoluted. I think everybody on here would agree that sometimes you get a little lost in trying to do it. So don't feel like, did you read that correctly? Or am I understanding it? The way that it's written frequently, as we do with the law, is we write one thing, then we write another thing to try to correct it, then we write another thing to try to explain it, then we write another thing to try to expound on it. And so sometimes it becomes just a little bit convoluted. Take your time, write it out. Kendall has an excellent PowerPoint here. Let it definitely be your starting point. But 46B is certainly your holy grail to make a determination. Can your client really, truly appreciate what they're being charged with and appreciate the punishment that comes with it and able to aid and assist in defense? What's your thoughts on it, Jason?
Yeah, I absolutely agree. Kind of early on again, coming in fairly fresh. I mean, it's your go-to. There's a few things that I keep on hand, and 46B is one of them. It's right there immediately when you come into my office. It's sitting on my desk. I mean, you're going to refer to it. You're going to want to get comfortable with it. I mean, especially if we have individuals that are just kind of getting familiar and getting started. get comfortable with it. It's convoluted, it's wordy, but it's going to give you step by step. Again, with that, translate that into your conversations with your client. You want to build that rapport. You want to build that trust. I mean, that is, again, something that is, you've got to step in, you've got to go see them, you've got to talk to them. Get in front of your client, try to limit any conversations electronically if you can. Go see them personally. If they're in custody, go to the jail. If they're out on bond, see if you can have them come to your office. But you've got to develop that rapport, and you've got to lean on that code.
That's great. 46B we're going to kind of walk through it specifically, but the few things that Jason and Vickie were talking about that I want to highlight are that you are presumed competent, and the defense's burden is to prove incompetency from the get-go. So that's kind of where we start with 46B, is finding them incompetent. How do we do that? So that's kind of where we want to start today. I want to give you a baseline of competency. We're sitting here, we're talking about it, but what is it? Lee mentioned that it is kind of, can they aid in their defense? Can they speak with their attorney? So it goes to their mental state, and it's based on a diagnosed mental illness, usually. The other option is a mental deficit, like IDD or traumatic brain injury, Alzheimer's. All these things may fall under competency, where they cannot aid in their defense. They cannot stand trial because they don't understand the proceeding. Competency is in the here and the now. It doesn't matter what happened at the time of the offense. It matters, can they take care of their case right now? This is different than insanity, which is also covered in the Code of Criminal Procedure, but it's 46C, not 46B. But insanity is at the time of the offense. You'll hear people say, did they know right from wrong? Did they understand what they were doing? Were they in touch with reality? That is all insanity, and at the time of the offense. That is different than competency. And something to note is you have to be competent to even be looked at for insanity. So usually you're addressing competency first if they are both applicable. So competency is what we're going to go through today. Another bullet point on the slide you'll see is just mental health in general. And I'm going to let Lee talk about that for a second, because there are many programs that we have in Dallas and that y'all may have in your counties that address mentally ill defenders, and those may be separate than the competency. So
Thank you, Kendall. Yeah, we have some things, because you will see, as Kendall said, you can be mentally ill and still be competent. You can be incompetent, be restored to competency, and then be determined to be insane. You could be insane without competency ever being an issue, but just be mentally ill. It can all get tied together. If you have a case where a person has been restored to competency, or most importantly, you just have that case where competency is not ever an issue, you've just got a mental health diagnosis. That's the ideal time, as Vickie said a while ago, to not just think outside the box, to just destroy the box in general. We have multiple programs in Dallas that have been set up. One is called Mental Health Jail Diversion, and the other is SET, Stabilization, Engagement, and Transition. To kind of save time, MHJD is the misdemeanor version of SET. It's 6 months in length. SET is 12 months in length. They're for high-risk, high-needs offenders that are selected. If you're selected to go into these programs, you're overseen by a judge, Judge Kristen Wade. You're with a treatment team. You've got a prosecutor who specializes in mental health and a public defender who specializes in mental health. Mm-hmm. They take your case, take it out of the normal court system, and put it so you can be working with a team to meet you where you are, to take care of your needs. If you successfully complete those programs, your case or cases are dismissed. And for SET, they are partially expunged at the end of the program. Another thing you can do, and we'll talk about these throughout, but another thing that we have is a PTI program. That's a pre-trial intervention agreement. That is a pre-plea intervention on a defendant's case where we use assessments. It can be a 1622 assessment. It can be school records. It can be whatever defense chooses to provide us to look at, to work with the doctor, to work with care coordinators, to work with case managers. Again, it's very collaborative, this whole process. We then put together a plan for that defendant to kind of meet him or her where they are, that if they work through the plan, then the case will be dismissed, or their cases at the end of the time. The key is collaboration. If defense brings me some information or brings Kendall information, our information is in a separate system. It's not going to go to every prosecutor in the office and be used against the defendant. Oh, here's what we learned because the defense gave us all this material. If we reject the case, that material is gone. We don't load it anywhere else. So I could talk a lot about that, but trying to be mindful of time. Vickie, do you have anything to add to that?
You know what? I cannot let us not mention a program that's near and dear to our heart, because partially reason that you're even here in Dallas County, Judge Rocky Jones, the Atlas program. You know, along with having pre-adjudication programs, we also have post-adjudication programs. And so the Atlas program is a post-adjudication program of individuals who have been diagnosed with a mental health issue, who have struggled on probation, and they've struggled on probation either due to their mental health or due to their substance use. And so we have post-adjudication programs as well. I think the takeaway from the whole situation, as Lee has indicated, is, you know, we've got to view individuals with behavioral health issues a little bit differently. And we got to have willing judges, willing prosecutors, willing defense bar that's willing to get in there, roll up the sleeves, and create problem-solving courts to address individuals with behavioral health needs, so that we can ensure that they are treated fairly and have the ability to receive sustainable treatment in the community, so that they don't cycle back in. Oftentimes, an individual with a mental health issue is going to cycle back in, not because of their criminogenic thinking. They're going to cycle back in because of their linkage in the community. So what we really, truly want to do is make sure that in your area, anyone can start off a pre-adjudication program. Anyone can start off a post-adjudication program. We have the blueprint here. We have the paperwork. We have the waivers. Just reach out to us. We'll be glad to aid and assist you with references to agencies that will start you with your seed money, from the Texas Indigent Defense Commission to JCMH, to just a number of grant opportunities that may exist out there to create programs, because that's the other takeaway from this whole concept of speaking about competency and behavioral health altogether, is we want to make sure people are doing everything they can to drive behavioral health back to the community. We don't want you to put us out of a job, and we don't think we're be out of a job. However, we would like to see the bulk of these clients that we are dealing with served in the community versus served in the criminal justice system. What do you think about that, Jason?
Yeah, no, I think that's a fantastic point. And I tell you, one of the main things that I love about this practice area and having these, you know, problem-solving courts at our disposal is it gives the defense an opportunity to be creative. I think, you know, we lose sight of that at times, but being able to rely on these other programs and saying, okay, well, let's maybe transition that, still allows for, you know, some monitoring and making sure that maybe medication compliant, things like that. But it still, you know, allows an opportunity, kind of what Lee was saying, for an optimal outcome. You know, let's get these individuals in the best possible position moving forward. And I think, again, you know, that collectively is a goal, and again goes back to, you know, collaboration is key.
And we'll talk more about the other diversion options later in the slides, but the reason I wanted to mention it here is because it's exactly what Jason is saying, is it's all about how you can help them as a whole so they don't come back into the system. And so that's why we're talking about it, because someone on a diversion program may go incompetent. Someone who is incompetent may restore to competency and may be appropriate for a diversion program. So even though it is not competency-based, it is behavioral health-based, and it's all intertwined.
Absolutely.
So we kind of wanted to go through a definition of competency. We've kind of talked about this a little bit, but the Texas Code of Criminal Procedure, Article 46B.003A lays it out and goes through, it's a person is incompetent to stand trial if the person does not have a sufficient present ability to consult with the person's lawyer with a rational degree of understanding, or a rational as well as factual understanding of the proceedings against the person. we talked earlier saying they are presumed competent until proven otherwise. That the burden of proving incompetency starts with the defense. It may shift later, depending on your fact pattern, but at the beginning, finding them incompetent for the first time is the burden of the person trying to find them incompetent. Competency is fluid. If you'll notice throughout the code, it'll tell you that the competency evaluations done by a doctor, it doesn't matter when you get the report. From the day the doctor saw the defendant, that report is only good for 30 days from that date. So even if they see him and don't get you the report for 2 weeks, you're only working with a 2-week timeline. The reports are only good for 30 days when it's an incompetent report. If it's a competent report, they don't expire. Do you want to pick it up, Carly?
Sure. And just a little bit about the deadline there. Be sure that you watch that 30-day deadline. We see a lot of problems. I know when I did the job, I'm not nearly as organized as Kendall. We would see a lot of problems come through before we would do, because by dropping that deadline, the hospitals might be delayed, defense might be delayed, prosecution. Really be sure and mind your 30-day deadlines, because that's just slowing things down in the system where we could get this person further down the list.
We talk about the big part about it, Lee. It costs money.
It does. It
Live
costs money.
report.
Yeah, and nobody likes to go to the court and say, hey, can we spend another, $500, Judge, because we dropped the ball, and it's collaborative. It's not the defense dropped the ball, or it's we dropped the ball, Judge, and now we're asking you to spend more money. Next practical pointer, if you believe the defendant has or may have IDD, then the type of competency exam given to the defendant must be validated on a subject population that has IDD. Talk to your doctor that you're using. Make sure he or she is going to do the right evaluation. Make sure they're doing the right thing. Same thing that you could throw in if you believe someone is faking mental illness. Some doctors are able to do malingering testing or do them. Others don't. Reach out and talk to your doctor. Again, the teams can work together, prosecution and defense. If you're looking for a doctor, some of the smaller counties may not have a doctor in that county. You can reach out to HHSC or JCMH. A lot of doctors are trying to do things through telemedicine now. So there's other resources out there, but it's a particular type of test that you have to do. Big issue. An indictment is needed on a felony criminal case before you can raise the issue of competency. I know Kendall sees this a lot. Well, we got the report, Lee's incompetent. Yeah, there's no indictment yet. Okay, so when can we go do the hearing? We can't. Without an indictment, there is no case. That competency report is dead. If the case is not filed, if there's no case yet, you cannot do a competency hearing.
Now, I just want to jump in there. Obviously, misdemeanor, it's upon filing. Felony is upon an indictment. Like Lee said, there has to be a case, because remember, it's not just you're incompetent. It's incompetent to stand trial on this criminal case. So you got to kind of finish the whole sentence. So if you can't finish that sentence, you can't be found incompetent on that case if there is no case. Vickie, Jason, do y'all want to jump in anything there?
But when you said that, it just brought to the mind of many people are like, well, what do I do? What do I do? They're just sitting there. They're just sitting there. Listen, you have to have jurisdiction. What if you send someone to the hospital and the case is not indicted? Now they're being illegally held. So what you can do is talk to your client. Talk to your client, get that baseline. You may be developing a here and present sense of what they're like with your doctor. If you think you're going to go the insanity route, you are also building your mitigating factor, what your client is like. Once the client is restored, to use that to aid and assist in negotiating how to resolve the case. So with it, I say, don't let that time sit dormant. If the case is not indicted, if it's not filed, talk to your prosecutor's office and say, I have someone that's really, really sick over there. This is what's going on, so that there can be a conversation about, one, is it worth it to even move forward on the case? But two, what can we do while the individual is there? Most jails have the facility to help and start treatment. And I know further down the road, we'll discuss other treatment options. However, most jails outside of those treatment options will offer classes, will offer medication. So your client may be quickening their ability to restore by going ahead and starting to work on it. And notice when I say restore and consult, I wanted to throw this in there. Consult means consult in the true sense of the word, not parrot. Anyone can parrot the terms prosecutor prosecutes, defense defense, judge judge, but can your client truly appreciate that they're facing 25 to life? Make sure you're doing the deep dive, people. Can your client truly aid and assist in their defense before you move forward and restore competency?
And to jump in there, we do that a lot. If defense contacts us and says, I have a person, I think they're incompetent, but I can't do a comp eval yet because the felony's not indicted. What can you do? Well, I'll turn around and email our intake division and say, hey, this person may be incompetent, not sure, don't have a report yet, but could you set it for grand jury sooner rather than later? See if we can't go ahead and get that in motion, and they can reach out to the police agencies, and maybe it gets in front of a grand jury faster to either be indicted so they can get the comp eval, or to be no billed and address it a different way. The other thing, like Vickie said, is if they can get on some meds in the jail, maybe we don't really say restore because they haven't been found incompetent, but maybe they can become competent and never need that evaluation in the first place once it's indicted down the road, if they've been on medications for a while or been in a drug-free environment for a while, or whatever the case may be. So those are options that they can do something here and now. It's just not a competency evaluation.
And if I could just jump in maybe a little bit on that. I think I may have been a little guilty of that, even when I, first kind of came in, saw a referral come through our office, and they haven't, been indicted. So of course, my first reaction is I panic and like, oh my goodness, did I miss something? But there's no indictment filed, so I stepped away. But what I did was, like Vickie was saying, you continue to work the case. So, I'm still going through the discovery. I'm still getting prepared to when this day does arrive, which will be any moment, and making sure that at least all the ducks are in a row. One of the other things kind of touch upon, I would also direct everybody to, rule 1.16 of the rules of professional conduct, speaking with an individual that has diminished capacity. We're still held to that same attorney-client relationship, but there are ways to where we can still get needed information with other avenues. So I would, again, suggest everybody, take a look at that if you haven't already. And this is, again, coming from a little wet behind the ears, the new guy. So yeah.
Excellent point, Jason. Say that rule again for us.
So rule 1.16 of the rules of professional conduct.
Perfect.
Yeah. And I think
all of
this, sorry, y'all. I think all of this that we've just been talking about points to the last thing on the slide here, the last big topic. Think outside the box before proceeding. Everything we've just been talking about is thinking outside the box. Prosecutors who may be on this call, if you get a competency report, this is something that we are starting to do in Dallas. Kendall and Vickie and the competency team, Jason, there's a ton of people that work competency. We're now getting staffed. We've been staffed fully for the past few months. We're starting to take a proactive look at, hey, Lee was found incompetent. What do I plan on even doing with this case? Do we need to put him on a list, put him through a program, do something here? What is the compelling interest to prosecute? There's a book that you can get, a pamphlet through the HHSC. It's called, it's a Competency Restoration Guide. And one of the things that is key in there, one of the key concepts from JCMH, anyone looking at competency is there a compelling interest to prosecute? Can we think outside the box? If we get the guy with a criminal trespass, this is his 50th criminal trespass, okay, we're going to find him incompetent, put him in jail, let him sit there. He's going to time out before he gets there because there's a wait list, which we'll talk about later. Or can we do some of the things that are listed here? Bond conditions. Can we do a civil outpatient program? Is there stabilization in the jail? Can we do a dismissal with linkage in the services to the community? And Kendall can speak a lot more to these things in just a second, but we have to think outside the box to figure out Okay, so the guy who's incompetent took an ambulance from the hospital, drove it a little bit and has a UUMV, but they got it back and there's no damage. What is our end game? What are we trying to accomplish here? Kendall, you want to?
Yeah, thanks. To me, it in Dallas, it depends on what county you're on, but in Dallas, it is hard in the sense that I'm the only felony competency prosecutor, and we have the second largest jail in the state. So we get quite a few competency evaluations. So for me, I've always had to find them incompetent, put them on the hospital list, and then hope to go back to try and look at the case after that point. Of course, it's already gone through a grand jury and stuff, but just look at it for the compelling interest to prosecute viewpoint. And now that we are fully staffed and we have yet another person helping with competency, what we have chosen to do is put that person in charge of reviewing the wait list. And so every day, all day, what they do is they go through the wait list and look at the fact pattern, look at the criminal history, look at you know, their hospitalization history, look at, we have an order which we can share with you at the end, where the courts can sign off to give you their medication records from the jail. Obviously, defense is a part of that. We agree to that and ask the court to let us have those. We can see if they're on their medicine, which is important in a lot of the cases, because sometimes, you know, maybe they weren't on any medicine and now they're taking it every day. Does that mean they're ready for a new competency evaluation? Does that just mean they're more stabilized? Maybe they were ordered to the hospital, but now since they're taking their medication, maybe they'd be ready for an outpatient program. So looking at the cases and continually evaluating them the whole time they're on the wait list, I think has shown a big difference for us in Dallas. We've always pretty much had one of the highest wait lists, and we are just now being able to attack that in a different way. Part of having a big wait list could be a good thing. It could be identifying mentally ill offenders in the jail. But we all know that these people have not been found guilty a lot of times as plea, and they're sitting in jail, and now we've got non-maximum security people sitting there about, you know, up to a year, maximum security defendants sitting there up to 2 years. And so I do think it's important to kind of figure out with what Lee said is, do you have a compelling interest to prosecute? What do I want to do at the end of the day with this case? Because if I'm not going to trial, if I don't think they need to go to TDC, if I don't think they need to be on probation, then do I need to even restore them? So can we get them on track with their medicine? Can we get them on track with any sort of monitoring instead of that? And that's kind of where the diversion programs that Lee was describing and Vickie was describing come in. Pre and post plea, you know, are those an option? We have something we'll go through here in a little bit called dismiss and civil commit. Is that an option? Bond conditions, dismissals with linkage to community services, is that enough? You know, each case is going to need individual attention because each defendant is different. And we are lucky enough to now have someone to do that. But in your county, if you don't, is there even a couple cases you could look at? Even if it's not the whole wait list every single day, is there anything you can do to continually monitor those cases to try and give you a way to think outside the box?
It's called being smart, not soft, but being smart in addressing criminal matters.
Let's see. Okay, the court's going to appoint experts to determine whether the person is competent or incompetent. A lot of times in your county, you may be using the same experts over and over, so you will get to know them. And other times, maybe you're using telemed if you're in a smaller county. That's fine too. Whatever you can do to get the examination, to get the report, to get these people help. Anything you want to add in, anyone?
Said
No.
it all.
Yeah.
There's a list of things they have to consider. You can look in the Code of Criminal Procedure. Again, it's 46B.024, and it'll go through the different things that they need to understand. I'm not going to sit here and read the slides to you, but you can go through there. They're all laid out exactly as they are in the code. So let's see. There are maximum restoration periods. Vickie, do you want to talk about maximum restoration periods?
Yes, at the end of the day, in the code, as Kendall says, it's going to be your holy grail. The maximum restoration periods, they range. Okay, and they range when dealing with the particular type of offense and what you're working with. And based upon that, you have to make the determination as to what you're going to be doing, whether you have a maximum restoration period of 60 to 90 days, whether it's up to 120. Pay attention to when it comes to your restoration period, because then it's going to be time for you to look to recommit them. And recommitting requires something different. It generally requires additional doctor's testimony, additional certificates, additional showing that the person is still incompetent. Now, understand this. While you're doing all this, you also have the statute of limitations of the charge that's running up against you. And so you can never lose sight of toggling back and forth between the maximum restoration period as well as the actual statute of limitations, because they're different. In a Class B misdemeanor, when they tap out, they tap out. Class A misdemeanor, when you hit that year, that's it. So as you continue to go with the different various statute of limitations, you have to toggle it against the maximum restoration period and what's necessary to recommit an individual. And sometimes this is where I frequently find it to get a little tricky, and you can correct me if I'm wrong here, Kendall. When an individual restores, they come back, they're lapsed back into being incompetent, and you now do another report, but you don't do enough reports because it's that weird phase of you were just held in custody within that time frame. This is why we say 46B is very intricate, and it's your holy grail in determining, do I need 2 doctors and testimony versus just a report?
And I've got a great one-pager I'm going to share with y'all here in a minute on those different recommitments. So we can kind of point some of that out, because yes, that is a huge burden or hurdle that we have here. Is someone will order 1 report and we need 2 for that one, or they'll order a PhD and we need an MD. And so knowing those things on the front end helps you be just more streamlined and more efficient. So we'll definitely go through those. On the maximum restoration periods, the main thing to take away is that you can be held for restoration on a felony for as long as you could have been punished without paragraphs, and that is your time period. So a state jail is a state jail. That's it. You don't have the paragraphs, it doesn't matter. It's 2 years. You've got your second degrees, you've got your first degrees. So those are the time periods. You do not have the paragraph time added. If they reach their maximum time, in misdemeanor world, you get 2 years of outpatient, or their maximum inpatient time, it equals a dismissal. In the felony world, it doesn't equal a dismissal, but it can. It just isn't required by the code. You have a maximum timeout, but then you have to kind of figure out what to do from there. Something that I know is mentioned on a future slide is you have the ability to dismiss and civil commit at the end. So if you've gone, let's say you're 2 to 10, you can go 10 years and you can't try to restore them anymore. But if they're still a danger to themselves or others, you may choose to dismiss, and now they're in a hospital bed under a civil commitment instead of a forensic criminal commitment. So they're still there, but now a doctor's going to release them whenever they're no longer a danger to themselves or others. It has nothing to do with competency restoration anymore. That would require a dismissal. Another example would be you get all the way to your time. They don't meet criteria for civil commitment. And so you may be releasing to the streets. You could do bond conditions maybe and release them to the streets and watch them and monitor them, but you have no teeth. There's nothing else you can do if they don't follow the rules, right? You've exceeded your restoration time. So even though it doesn't force you to dismiss on a felony, we are always dismissing those because we have reached our time, and either you meet criteria for the civil commitment, we dismiss to that, or you don't, and we dismiss to services. There's no reason to keep cases hanging out there where you are barred from prosecution in the future. So do you have anything else you want to say on that?
Not so much about this, but some terms that are mentioned in this slide, I was just noticing. I don't think they're specifically spelled out in future slides. You see the term jail-based competency restoration, outpatient competency restoration. There's 3 ways you can try to restore somebody. Inpatient, and that's that wait list that we've been talking about, and you'll hear more about it in a few minutes. There's an outpatient competency program. We have one for misdemeanor and felony cases here in Dallas. That's if a treatment provider says, hey, we've got a plan, a doctor recommends that Lee gets outpatient to try to be restored, and that can be done safely in the community, and the treatment provider gives us a plan. Okay, we're going to work with him outside the jail to see if we can get him restored. And then jail-based competency is just what it says. While we're going to try to work with him in jail to get him restored and see if we can't get him out quicker. So I just noticed those terms there. I wanted you to know what those are. There's a combination of counties can have any combination of those. You can have JBCR, you can have OCR, you can have for felony misdemeanor. Some places don't have any, some are trying to start it. If you don't have one and want to start one, again, all these resources or any of us on this call, there's a lot of places you can go to try to get that started.
And Jason, will you talk a little bit about JBCR, just because in Dallas, we have our local mental health authority comes into the jail and runs the jail-based program, but they really communicate with defense, not with the state. So kind of, can you walk them through what y'all do on your end as a defense attorney with jail-based competency?
Yeah, I can generally, and Vickie may have to kind of pick up some of the pieces on me as well. But yeah, essentially, it's a great avenue for defense. Again, practically speaking, with an individual in a case just a while back, the recommendations inpatient, if we've already discussed, the inpatient wait list is pretty excessive. So you may want to go ahead and send out the request to have the provider come into the jail and do the assessment, see if they are, eligible for the jail-based restoration program. It's going to essentially fast track their, opportunity to regain competency. They're going to be seen a lot quicker. They're not going to have to sit and just wait. So it's a great avenue, I think, for defense in that sense. But, additionally, it gives you, again, that connection, kind of what I was saying. You now have them to where it's easier to monitor. You're going to, have this direct line of communication. You can check up on them. And again, kind of going back to what Kendall had said, you may want to, they may get a report back saying, okay, well, let's go ahead, let's do a reevaluation. They seem like they have regained. So let's get that moving. And again, Vickie, you may want to fill in a lot of those gaps. I think I probably said quite a few.
You did a great job, Jason. Our rookie is, making us proud every day. The simple thing when it comes to all of these programs is the curriculum is similar and the same. And in jail-based, just as Jason said, it gives an opportunity to get them off the wait list because unfortunately they weren't identified for OCR. But while they're in jail-based, they may can prove to either the doctor, prosecutor, as well as the judge that has to sign off on it, they are now appropriate for OCR and to get them off the jail list. So jail-based serves two folds. One, it may aid and assist you so that once you are picked up for the hospital list, you're just that further along. Two, you may be able to convince them that you're appropriate for OCR, and you may find yourself out in the communities being served in the community. And frequently, when you're out on OCR, what I tend to see is that's an opportunity to show to the state, I am stable and I am engaged. And Kendall and Lee can correct me on this one, but that's my opportunity as a defense attorney to say, look how well my guy has been doing. Look how great he's been doing in jail. Trust him on OCR. Look how well he's been doing out on OCR. Trust him on a PTI once that individual is restored. So you're being looked at and being seen. And again, as Lee indicated, through JCMH, as well as through the Texas Health and Human Services, there are many opportunities to create an OCR program as well as a jail-based program. And if you do not know who your mental health authority is, you shouldn't even be on this call. The first thing you have to know is, what are your resources out in the community? What are you working with? And frequently you have to start with, where does the money go? And the money goes to the mental health authority. Get your mental health authority involved in these competency cases, because they are, in essence, charged with that duty to monitor that list and move these clients along to see what is out there and what is available to kickstart either a jail-based program or an OCR program in your area.
And I just want to point out two things when they were talking, it reminded me, in Dallas, our jail-based competency restoration program was set up as a pilot program. If
Good.
you're familiar with the code, you'll see that that's a separate section than other people's jail-based programs. So you in your county may have court-ordered jail-based. We have that on certain misdemeanors, but for the most part, Dallas is a voluntary jail-based competency restoration program. So if you hear minor differences in us talking to what your county does, that might be why. The other thing is, one important thing, I know we said it, but just to highlight it, is on this slide where you see if a defendant is charged with a misdemeanor and has been ordered only to participate in outpatient treatment for restoration, then the maximum period is 2 years. So when we were talking about felonies and we said, hey, if it's a state jail, you've got 2 years, and going with the exact timeline, on a misdemeanor, you do have the timeline for inpatient, but if it's outpatient, your misdemeanors are up to 2 years in outpatient. So I just wanted to highlight that for restoration purposes.
And you
All
know
right,
what,
let's go
I
on.
would tell them, Kendall, if you don't have Kendall's fact sheet, the little quick guide, you're starting off wrong. Yeah, all these little nuances, and Kendall, no, I have to give you kudos. You did an excellent job of pulling all the information together. It's the pieces that frequently trip people up when dealing with 46B and the health and safety code, because there are little twists and twerks that you have to be able to know so that you're doing the right order. And so that you're sending individuals to the right facility, and that you have, and everyone on the team is aware of the different time frames that they have to either restore, not to restore, so that you can plan appropriately.
And I'm going to pull that one pager up for the competency hearings in a couple more slides. So yes, I'll be happy to share that so it can be sent out as well. Because I do think it took me 10 years to create, understand it and create it. And I'm like, oh, I wish I had this sheet on day one. So I'll be happy to share that with y'all. Let's go to agreed incompetency. We're going to go a little faster just to be mindful of the time to get through everything. But you can agree to incompetency. Do you want to take this, Bartley?
Sure. Most of ours are agreed incompetency. And just to give you an idea of what the competency teams are dealing with monthly, these folks work all the time. Kendall gets 80 to 100 new competency reports a month. And that means the public defender's office is getting those reports. The private bar is getting those reports. The courts are getting those reports. As Vickie and Jason and Kendall, everybody has said, we have doctors that we use. We're familiar with those doctors. We trust those doctors. We don't trust the doctors when we like what they say and distrust them when we don't like what they say. It is what it is. The reports are what they are. Most of ours are agreed. And most of the recommitments, we're trusting what the hospitals say. Hey, Lee's been here for 2 years. We need to recommit him for another 12 months. Boom, they do those as well. So I'm not going to say much more on that, so we can keep moving.
If we have evidence of malingering, if you're listening to jail calls and they're talking about how they're going to get out of it by pretending or something, that's different. But just on its face, if there's nothing else to tell us that they are competent, we usually will agree to the competency finding. If it's contested, do you want to go through that defense?
If it's contested, you have the right to a jury trial or a trial by court. And you do it just like you would do any other standard case. You pick your jury members between 6 to 12, depending upon what you're dealing with, and you try it just like a case. And it becomes a battle of the experts. Therefore, if you're truly going to contest a competency, you should have, as Kendall said, a good basis for doing so. If not, you've just wasted a lot of money and a lot of time to get to where we needed to get to before, because it is a trial by judge, it is a trial by jury, and all the bells and whistles that go with it.
Something too, I think that you've got to look at for the jury trial is a couple things. What happens in the competency trial stays in the competency trial.
True.
You can't start using that against the defendant. Now, if the defendant opens the door in trial in some way, but just look at it, what happens in competency stays in competency. You know, and you're looking to prosecutors, look at this case. What are we trying to do? Is there a compelling interest to prosecute this person? You know, when we get that competency report, what is the interest of justice? You know, the prosecutorial rule, I don't have mine to quote like Jason did, but we're to see that justice is done, not just moving this case down. What does justice look like for this defendant that's got this competency issue?
Well, in that contested competency hearing, Lee, just as you're pointing out, it's a contested competency. It has zero to do with the facts. We're going to get up here and you're saying my guy is competent. I'm saying my guy isn't competent. And we're just going to go back and forth, back and forth. And we may end up with a stalemate where we may have to have a third doctor to come in because the judge feels like at the end of the day, your expert's going to say what your expert wants. This expert's going to say what this wants. Or if it's the jury, you know, they may themselves, you know, end up in deadlock. So again, if you're going to move forward with a contested competency, please have a compelling reason to do so, because if not, you're just wasting a whole lot of money to get really very minimal effect on the case.
And I think that's just kind of boils down to, why are we contesting? You know, do we have a reason to say like, I don't think so, prove it?
Right.
Or are we saying, hey, you know what? If the doctors who are trained forensically and have the qualifications believe this person's incompetent, who am I to say no and go forward and prosecute them? Because we should want justice to be done. And if someone doesn't understand the proceedings, you shouldn't want to go forward. So I think that's kind of the end all be all in Dallas of kind of how we decide to agree or not to. If you do go forward to a trial, jury has to be unanimous in its decision. If they find them competent, then the trial court can go forward with the actual trial on guilt or innocence. A lot of times, if we have a contested hearing, we put it as close to the trial of the case as possible, because competency is fluid. It can go back and forth. So just because they're found competent today doesn't mean they're back incompetent before the trial. So we try and run it right up before the trial if it's already set for a guilt innocence trial. If you do a guilt innocence trial, the jury is a different jury than what heard the competency trial. Here's the overall view of commitments, and this is the one that I actually want to put up the one pager on. So let me get that up on the screen for y'all. Can you do that off your email, Lee?
Yep.
I'll take this opportunity to remind you that we only have 7 minutes left.
Okay, well, I'll just go ahead and say that we'll go back to here then. I will make that available so everyone can see it and have it in hand. Basically, there's what we call an initial restoration period. You can only have one of those. The exception is if you have a case that then pleads and goes to a probation violation, you can count the probation violation as a new quote unquote case and get a new initial restoration period. There's another thing called a possible 60-day automatic extension. Also, there's only one of those that's possible. Those are not things you need to have a hearing on. They are more ministerial. The facility who's housing the person or the outpatient program who's housing the person has to send a letter to the court on their letterhead, signed by the person in charge of the facility saying, hey, they're not competent yet, but we think we could get them competent soon. Give us a 60-day extension and we'll continue the restoration. Then you go on to what I call extensions. The code will call civil commitments. For my brain, that is very confusing because there are also civil commitments without charges pending and civil commitments with charges pending. And so when I had started, the person who taught me called these extensions. And so that's just kind of what is in my head. But basically it's 46B.102 or 103. 102 is the mental illness commitment. 103 is the IDD commitment. And again, this slide, they'll go through and list out the differences and what you might look for. When you're doing a 102 extension hearing, there's a list of questions on these slides that you have, so you can ask the doctor those questions. Defense is the one who can ask this if they're trying to prove incompetency. A lot of times state does it in Dallas because we don't only deal with the mental health public defenders on this call who are very well versed in it, but we also deal with people in the private bar, and some are very well versed, and some may have one case a year that has a competency issue, and they might not know everything there is to do. And so if they don't, I can jump in and ask these questions. It really doesn't matter because it's an agreed hearing. But usually in your practice, you will probably see defense asking these questions. The only one I want to point out is this: has the defendant received court-ordered inpatient mental health services for 60 consecutive days in the preceding 12 months? If that is yes, you are doing an up to 12-month extension. If that is no, you are doing what's called a temporary extension, and that's under the Health and Safety Code. And those can be up to 45 to 90 days. And the reason that may come into play is if someone is incompetent and then restores and then goes back incompetent, you're really looking at that last 12 months. How long did they stay competent and to whether they went back incompetent? So that's that kind of 60 consecutive days in the preceding 12 months. Intellectual disability, I'll just say that you can't go straight to the state-supported living centers on a violent offense. You can on a non-violent offense. So if you have ag assault with a deadly weapon, you're probably going to Vernon and then the state-supported living center, not straight to the state-supported living center. State-supported living centers are part of the hospital system, but they are not there to restore somebody. They're dealing with the IDD population. They have programming at that level, and they're really working with them to get them to the community at some point. And so you can kind of go through that. The main thing is you've got to prove that they have an intellectual disability. If this is what we kept talking about, civil commitment charges dismissed. If someone has been found incompetent and they meet criteria for a civil commitment under Health and Safety Code, Chapter 574, you can dismiss their case and they can be civilly committed. That is in addition to, even if you ran through the whole entire maximum restoration period, you can dismiss at any time or at the very end when you've run out of time and still have this option. Here, our local mental health authority finds the bed at a local area hospital. They stay in our jail until they're transported, and then the hospital will release them when they're no longer a danger to themselves or others and have a plan upon the release for them. Kind of talked about this. You can dismiss outright at any time. That's if you're looking at compelling interest to prosecute and decide you don't have one, you always have that option. Something we do now that we are fully staffed is look at people who have been in the hospital and may have stabilized. So one of our largest hospitals is Terrell State Hospital. We've reached out to them and said, hey, tell us who you think might be ready for outpatient. Go through all the defendants from Dallas County. We're open to looking at these things. And so we have a great relationship with them, whether it's dismissed to services or to modify to an outpatient program. Do you want to?
This is just general hearing procedures. I'm not going to read this slide to you or even talk about it very long. I don't want to kill you from boredom here. I just want to point out the JCMH, the Judicial Commission of Mental Health, and in full disclosure, Vickie and I are both commissioners on the Judicial Commission of Mental Health, has a bench book that talks about competency, insanity. It talks about everything. It's very, very useful. It's very practical, and you can just reach out and you can get one. HHSC, Health and Human Services Commission for Texas, has a competency restoration toolkit. Very helpful, very practical. There's charts out there. We can send you charts and things as well. There are a lot of resources. It walks you through what to do with these. I know our time is up, but as you can tell, this is a complicated, time-intensive, a lot of little pieces, and this is the Cliff's Notes version of it, and we had to move through it to get through it in an hour, and we're still not totally there. The learning curve for competency can be 2 or 3 years before you feel comfortable doing it. So imagine if you're a defense attorney who sees it once every now and then. Jason, Vickie, Kendall sees it thousands of times a year. This is a complicated process. So there's a lot to learn. There's a lot of resources for you. That would be my closing statement.
Well, I think it's much like Lee just indicated. You know, JCMH has a conference that's coming up. I employ everyone to go to that conference because that conference we will cover a lot of the issues that's going on with behavioral health. There are multiple conferences that are going on centering around mental health. That includes also civil commitment and how it splinters from 46B and to involuntary commitment in the community. My plug to anyone is, if you do not know who your mental health authority is, find out who your mental health authority is, get familiar with the JCMH materials, get familiar with the HHSC materials, but most importantly, get involved.
And the last thing I want to say, I know we're out of time, is we didn't get to these slides, but don't forget to restore the person to competency before you plead your case.
Yes, that's the interceding thing. They must be restored, please.
That's true. We only want to do this once. You know, we are not paying any of these panelists, but we could not have actually paid for better advertising. So thank you. Thank you to our experts. Thank you to our audience. Please watch your email in the next few days. You're going to get links to all of the resources we've been discussing today. Kendall's one-pager, the bench book, a link to the registration for our annual summit that's coming up in November 2024. And we hope to see you all again on July 25th to talk more about jail-based competency restoration and court-ordered medication. And then one more time in August 15th, to learn about what happens when somebody cannot be restored, what options are out there. Thank you all very much, and we will see you next time.
All right. Thank you, Ms.
Thank
Molly.
you.
Thanks, y'all.